Like some people out of the hallway so we could have a full audience. No, we're talking state fair.
Meeting will come to order. Roll call, please.
Representative Alderman.
Present.
Representative Allred.
Here.
Representative Banks.
Here.
Representative Conrad.
Here.
Representative Crago.
Here.
Representative Davis.
Here.
Representative Slagle.
Present.
Representative Winter.
Here.
Chairman Eklund.
Here.
Thank you.
The first order of business will be interim topics. They will be due tomorrow. So if you have an idea, we do have a few that I know of. One would be we're continuing to work on the foreign ownership of ag lands. And if there are other ones, let me know and we'll get them ready for a meeting Tuesday morning that we'll have. So with that, our first bill for consideration is Senate File 13. No, it is not Senate File 13. Which one is it? There it is, Senate File 14. And with us today is the Director of the State Fair. We're always glad to have you here. Come on up, Mrs. Conkle.
Good morning, Mr. Chairman, members of the committee. Thank you so much for the opportunity to be here today and talk with you a little bit. I'm Courtney Conkle, and I serve as the General Manager of the Wyoming State Fair. I'm here today to voice our support as the State Fair staff and the State Fair Board for Senate File 14. There is one sentence that, after having some conversations with our Board of Directors and with our Attorney General representative, that we did want to bring to your attention, because I think that the intention of this bill, the way it's written, is to give the State Fair Board the power and authority to be able to act nimbly if something were to occur where we need to switch out a contract or execute something rapidly. So in the end of the first paragraph of the addition, the final sentence reads, "The Attorney General shall review all contracts under this paragraph before the contracts are finalized." So that is above and beyond what they
Okay.
do for any other department or division. So we would just like to make the recommendation that that would be completely taken out. Of course, all contracts over the threshold would still go through the cobblestone system, so they would still be reviewed for form copy, but they would not have to be reviewed line by line by the Attorney General.
Mr. Chairman,
Okay, yes.
I apologize.
Oh, it's,
What page and number?
yeah, we were fumbling to find it and I
No
don't know if I
problem.
even heard what you said, so.
That's A-okay. Well, and mine printed without the lines, and so it's on,
Okay.
in my copy, page 2, but it's the end of the first paragraph of the new edition.
So it'd be page 3, the last sentence of that paragraph would be line 4, the Attorney General shall, is that?
Yes,
what's that?
sir.
Okay, over there. Go ahead.
Thank you, Mr.
Representative
Chairman.
Crago.
Thank you, Mr. Chairman. Just so if anybody's following along at home or online, it's actually in the engrossed version, which I don't think you have there, Mr. Chairman. It is on page 3, lines 9 through 11.
Thank you, Representative Crago. Yes, I was following along on the original one.
So, Mr. Chairman, if I just might add,
Okay.
then this would put us in alignment with the other departments and divisions where we would still be going through the state contracting policies and procedures, but we would not have any additional steps that other divisions or departments are not applicable to.
Okay. So how should that sentence read again?
Mr. Chairman, theoretically, it could just be removed.
Okay. I'm pretty sure I have the engrossed version. Let me find my own. All right, so is that the only change that you had?
Yes, sir, Mr. Chairman.
All right. Yes, okay, so by removing it, you will be more nimble is.
Yes, sir.
probably- Yeah, okay, which was a lot of the object of the changes. Okay, committee, any questions? Yes, sir. Representative Craigo.
Thank you, Mr. Chairman. So the Senate on their end added some language, which is on page 4 of our document regarding the membership of the board. Were you present for that?
Mr. Chairman, Representative Craigo, I was present for it. They were recommendations that were brought forth by Director Miyamoto, who's present, would be able to speak more in depth as to why those were recommendations.
Okay, I will ask the director. Thank you.
Okay. Any other questions? Yes, Representative Conrad.
Mr. Chairman, just a quick question. And I apologize in advance on page 2, line 13 through 15. I don't have the history, and again, I apologize. Why was the disbursements of all funds appropriated, the responsibility of which removed from the director?
Mr. Chairman, Representative Conrad, over the years, we've looked at potentially having one of the State Fair Board members be the fourth signatory on our contracts over $1,500. And the way that the statute is written today, it reads that the director is responsible for the proper disbursement of all funds, which the Attorney General's interpretation was that is the reason why the director was serving as the fourth signatory for any contracts that were expending state funds. We are a run-through budget, and so even though our money is affiliated with the Department of Agriculture, technically the State Fair Board and the Finance Committee and myself are responsible for ensuring that those funds are being properly dispersed, but statutorily, Director Miyamoto would be responsible today.
Thank you.
Yes, sir.
Yes. Representative Slagle.
Yeah, thank you, Mr. Chairman. Director, the question I would have, you mentioned that the removal of that last line and the paragraph on page 3 of our document wouldn't affect funds. And so is that $15,000 you were just mentioning here earlier? Anything over that would still require the Attorney General's approval?
Mr. Chairman, Representative Slagle, the way that it actually operates today is anything over and above $1,500 for the Wyoming State Fair, we run through the Cobblestone system. And so it gets reviewed for form copy by the Attorney General's office. We would not have to necessarily run anything above a certain threshold through the Attorney General's office for formal review. We do that as a best practice for any agreement that we're concerned about for any reason that we want to make sure is really a strong document. Our Attorney General Representative J.D. Slater has been incredibly helpful with that over the years of helping us to refine our agreements so that they'll hold water in the event that something ever occurs.
Thank you.
Okay. No further questions. Thank you.
Thank you.
I think we'll have Director Miyamoto, if you'd come. You could stay there, Courtney, in case we need you, just stay put. We'll have the director weigh in as well on what we're doing.
Good morning, Mr. Chairman, members of the committee. Doug Miyamoto with the Department of Agriculture. The engrossed version of this bill is something that would be easily implementable by the Department of Ag. We don't see any issues that would prevent us from being able to carry out the provisions of this act as it's presented to you. So I'm happy to answer any questions that you might have, but don't really have anything specific to add to the version today.
Questions? Yes. Representative Conrad.
Chairman Eklund, thank you. Director Miyamoto, a question on page 4, specifically line 1. Can you help us understand why after director, you've added the words "or the director's designee"?
Mr. Chairman, Representative Conrad, yes, that was for consistency of the ex officio members of the existing State Fair Board. So you know, I would sit on that board as a result of the job that I hold. Similar to, if you look in that statute, the governor has the same authority as does the dean of the UW College of Ag.
And follow up?
Yeah, follow-up.
Chairman Eklund, thank you. Director Miyamoto, so that was something we've never had in there before, oddly enough?
Mr. Chairman, Representative Conrad, the statute as it's written today was developed in 2018. It was always worded about, it always had the wording regarding designees for those other ex officio positions on the board, but not for the director of the Department of Ag.
Thank you.
Times I would think that'd be a necessity, that you'd have a designee rather than being there yourself.
Mr. Chairman, that's proved to be the case over the past 5-6 years. There's times that I'm available and that I can go, but there's other times when we just have too many different conflicts and things going on, other boards and commissions of which I take part that sometimes conflict. And I think consistency on the State Fair Board is important as well. So having that flexibility would be a benefit.
Yes, okay. Looks like no further questions. Thank you. And do we have public testimony today? It looks like we don't have any, no one online. Okay, committee, what's your pleasure? I'll close public testimony. Thank you, both of you.
Move the bill, Mr. Chairman.
Moved by Conrad, seconded by Allred. Discussion on the bill? Question? Nope. Got it. We have one, I would move that on page 3 of the engrossed copy, line 9, beginning with that last sentence, the Attorney General, and on through the end of line 11, that we would remove that sentence. Been moved and seconded by Davis. And does everybody kind of understand why we're doing it? It keeps the Fair Board more nimble and able to execute some of their plans without, anyway, it makes the Fair Board consistent with what other departments are doing. So all those in favor of that amendment, say aye.
Aye.
Opposed? Okay, that amendment passes. Any further changes or discussion? I think we're ready to vote.
Representative Alderman.
Aye.
Representative Allred.
Aye.
Representative Banks.
Aye.
Representative Conrad.
Aye.
Representative Craigo.
He's excused. Did he leave a proxy? We'll hold his vote open. He's not going to be gone for long.
Representative Davis.
Aye.
Representative Slagle.
Aye.
Representative Winter.
Aye.
Chairman Eklund.
Aye.
How do I count him then?
I don't know. We've done
gonna
this
pass.
before. I think just go with excused for now,
Okay.
and he'll, when he's
8
back.
ayes, 1 excused, and this is the 14 passes
Okay,
with amendments.
thank you. Next bill for our consideration is going to be one that I'm surprised that the Ag Committee got, but there's one portion of it that does affect waters of the state, and I think that'll be the main part. We'll work on most of its crossing Ts and dotting Is, and it's a fairly important bill. It's been worked on by Management Council. So is there testimony on this bill? I guess what I would say is, as we go through it, most of it is just that. It's putting an S on the end of commissions or just details until we get to the last page. And the last page, well, not
Chairman?
quite the last page. Yes, sir. Oh, I'm sorry.
Which bill?
We are on Senate File 83, Revisor's Bill. Did I not say that?
No, sir.
Whoops. Well, thank you for calling that to my attention. And it is unusual for the Ag Committee to have this bill, but we can handle it. So most of it are just simple, tiny changes, and then you get to page 9, the end of page 9, and you get into a sentence that's really substantial. And we have the, let me see who we, there. We do not have the Director of Select Water, but we have his designee, Mr. Mosier, come on up. When you're ready, you may go ahead and explain maybe the history and why we're even discussing this.
Thank you, Mr. Chair. My name is George Mosier, and I represent the Wyoming Water Development Office. Director Mead is unfortunately booked in another conference right now for another bill, so he sends his regrets that he's not able to speak directly to this. Our office is here today to provide comments relative to Senate File 83, the Revisor's Bill, particularly on the engrossed version, page 9, as you introduced, Chairman, lines 22 and 23, which were added as an amendment to the original Senate filing. The office understands that the Revisor's Bill is intended to make non-substantive changes to existing legislation. However, we are concerned that this language may be substantive and may actually impact the operation of the water development program. The origins of this particular subsection date to session laws from 1986. And it is true that the original statute from 1986 included the language in lines 22 and 23. However, this subsection was considered by and was amended by Senate File 35 during the 1998 special session. It became Chapter 6 of those session laws. And to this day, the subsection remains relatively unchanged. Significantly, in 2021, members of this committee will probably remember that the omnibus water bill construction that year made some changes to how this particular statute might be considered, particularly for a preceding paragraph. The preceding paragraph in the water statutes was changed to allow the Water Development Commission to determine that excess Stage 2 water was no longer needed and to terminate any existing contract with the City of Cheyenne for excess water or for contracts pursuant to this subsection G that you find in front of you today. Significant changes of that particular subsection 9999-210E reads in part, upon termination of any existing contract entered into pursuant to that subsection and subsection G of this section, the excess water shall no longer be assigned to and marketed by the Wyoming Water Development Commission. Most likely, Mr. Chair, the crafting of that 2021 legislation relied upon the language in G as it currently appears without the two lines that have now been inserted. In fact, the 2021 language and intent might very well have been different if those two lines were in fact included on the books and were available for viewing. So those two lines likely impact the work done in 2021 and will in turn impact the responsibilities of the commission. While a holistic review of 9999-210G and 210E may be warranted, the office is concerned that the Revisor's Bill may not be the appropriate mechanism to accomplish that. And with that, Mr. Chair, if there are any questions, I would be happy to field them.
Mr. Mosier, what would be the suggested vehicle to fix the problem or the oversight that's happened? what would your office suggest? You probably have a better plan. I hope you have a better plan.
Well, Mr. Chair, thank you for that. I contemplated that a little bit and, perhaps a review of those concerts altogether or those statutes altogether would be appropriate. I'm certainly not here to take a position on the intent of those. But I think the bigger issue for us is just the mechanism under which it's accomplished, whether it's a reviser's bill or it's its own piece of legislation.
I think I would agree that has to be considered because it's a substantial change and most of the reviser's language is just grammatical fixes and tiny little fixes. This one's not too big to figure out, but too big to be in this bill probably. So, committee. Yes, Representative Conrad.
An unrelated question is if we can refer to, I'm sorry, Mr. Chairman, unrelated question, if we can refer to page 7, line 8. What was the thought behind removing commissioners to commissions?
Yeah, this wouldn't be your.
Mr. Chair, I didn't arrive to intend to speak to any particular language within this bill. As a matter of fact, I don't think that particular part applies to the Water Development Commission.
That's the beauty of showing up.
Yeah. Yeah. You could make note of the fact that my committee tends to be a little ornery at times. But, so, yes, Representative Craigo, while we're on that last part of the reviser's bill.
The ornery part or some other
Less-
part, Mr. Chairman?
Much less ornery part.
Okay, and I'm sorry I missed the beginning of your presentation, I apologize. My question was, how did this particular language get put in the reviser's bill? Who suggested that we put that in there? And the second part of my question would be is if we take it out, because I think we'll have trouble on the floor if we don't. I mean, people do read the reviser's bill and they'll ask questions about it, and obviously it's substantive change. It's not grammatical. In fact, I don't even think it fits within the title. I mean, if we go look at the bill title, I don't think it would fit within that language. So those are my, two questions. A, how did it get in there? Why is it in there? And B, if we took it out, is there anything emergent that's we're gonna cause major problems for you guys if we take it out?
Yeah, Director, if you wanted to come up too, you may and weigh in whenever you need to.
Mr. Chair, in response to Representative Craigo's question, this particular provision amending 9999-210G was added as a Senate amendment on the floor.
Okay. That, are you?
Follow up,
Follow
Mr.
up.
Chairman?
Go ahead.
And this might be for the director. If we take it out and we decide to work that issue through this committee over the interim, and that's something we could look at, I think that'd be a good topic for us to look at, or water, either one or both. Would that be okay, or is this something that is emergent that has to happen right now?
Mr. Chairman, Representative Craigo, I don't think taking it out affects us. I think putting it in affects us more. So I don't know that it rises to the level of an interim topic, to be quite honest, but something that probably should be worked out in the interim.
Okay. Any other questions? Okay, so we may have changes to the bill. Representative Davis.
Thank you, Mr. Chairman. Director, why would the Senate insert this language in there, I guess would be if it's Is there some background or something that we're missing or not aware of?
Mr. Chairman, Representative Davis, I don't know the answer to that. We just saw this and it came to our attention. We looked at it, which is why we're here today. I don't know the genesis of it.
Okay,
Thank you.
we'll possibly remove it and then try to find out more about it as we go, but I don't know. It just probably shouldn't be here, is what I do know. Okay, any other questions? Thank you, gentlemen. Any further testimony? Did the city of Cheyenne want to weigh in on it all? It does affect you as well, sort of. I know you're downstream from it.
Frank Strong, I'm the engineering manager for the Cheyenne Board of Public Utilities. We're of a similar concern in the language in 21. It kind of created that 10-year window, and our contract with water development has since been terminated. So we're trying to understand how this would affect us and in our operations. It kicks up a few red flags.
Okay. Well, thank you. Any questions? All right.
Thank you.
Thank you, sir. Any other testimony on Senate File 14? I'm in the wrong bill here. No, I'm not. I'm having trouble with numbers today. Senate File 83, the reviser's bill. Any other testimony? Okay. No one online, correct? So we are finished with public testimony, and we'll close that. And committee, what's your pleasure? Moved by Crago, second by Slagle. Discussion on the bill, committee. Representative Crago.
Thank you, Mr. Chairman. I will propose amendment, starting on page 9, line 17, strike the remainder of that page and all of page 10.
Okay. Moved and seconded by Banks. Mr. Secretary, you have that? Okay. Any discussion on that? Representative Slagle?
Yeah, the question I'd have, Mr. Chairman, be, is that the whole amount of language that was amended in by the Senate?
Believe, yeah. Representative Crago.
Mr. Chairman, it is not. There was a separate amendment that dealt with, on page 4, beginning on line 12, extending through page 5, line 2, that was also added on the floor by the Senate. That one, I don't know, that's also a substantive change, but it may be less substantive than what we're dealing with right here on the water issue. I don't know. I mean, that's something we could take up on the floor. We could maybe do a little research since no one's here to talk to us about it, what it actually does. But it's not, again, that is not that's not a technical / grammatical correction like we usually see
Correct.
within the reviser's bill. And so I suspect that one might be one we have a discussion on the floor about as well. But those are the two amendments.
Thank you.
Okay, any other discussion? We have not voted on the first amendment, have we? Okay. All those in favor of the amendment, please say aye.
Aye.
Opposed? That amendment passes.
Chairman,
Yes,
I have
sir.
a question. I believe the amendment was strike 22, 23 on page 9 and all of 10?
Yeah, on page 9, starting on line 17, strike it all the way to 22. So it would take out that entire
That was my
portion of
question.
the revision. Okay? All righty. Are we ready to vote on this bill? Roll call.
Representative Alderman.
No, we voted on the amendment. This is on the bill.
Representative Alderman.
Aye.
Representative Allred.
Aye.
Representative Banks.
Aye.
Representative Conrad.
No.
Representative Craigo.
Aye.
Representative Davis.
Aye.
Representative Slagle.
Aye.
Representative Winter.
He
I
voted?
have his.
Okay.
Chairman Eklund.
Aye.
Ayes 8, 1 no, do pass with
And-
amendments.
And I held the vote open for Representative Craigo if he wanted to vote on the state fair bill. You were gone.
Aye.
Okay, so we'll close the vote on that now. Next bill for our consideration is, now we're to Senate File 13. I've been wanting to do this for quite a while, but it's federal land use plans, legal action authorized. So when this was done, thank you, folks. When this was done, I wasn't around in the interim, so if anyone on the committee would, and I think we know what it's about. We went into legal actions concerning the Rock Springs plan, and it was a necessary deal, and expediting that plan was probably difficult because I don't know if we have any place to get money. And that's what this is attempting to address. So I don't understand for sure how much discussion was made. It would take money out of the LSRA. That's the biggest deal. It'd be $50 million as a possibility. But it's a lot of money and it's a legal action that we have to be ready to stand on. So do we have anyone there at the time, the discussion on the LSRA possibility of other funds that could be used besides that? Was there any discussion on because I think right now, I'm guessing the governor's using funds that he has available to combat that situation. Anyone know much about that? Thank you. Representative Craigo.
Thank you, Mr. Chairman. So my recollection of the interim work on that particular language regarding the source of the funding was not extensive. We did not really talk about whether that be appropriate coming out of the general fund, LISRA, or some other source. Yes, the governor does have separate monies that we allocate to his office to prosecute these actions on behalf of the state. This is a little different. This is saying we can hire our own lawyers, separate and independent of the executive branch. And so that's why there was a dollar figure put in there. And to be honest, there was a little bit of discussion on the amount of money, but not on the source of the money. I don't even think that was an issue that was debated or talked about. I think it's a valid debate, but was not had during the interim.
Thank you, Representative Craigo. Any other discussion? Go ahead, Representative Slagle.
Yeah, thank you, Mr. Chairman. I would agree with Representative Craigo's assessment of this. I think the biggest point was allowing the legislature to hire additional legal help in case we ended up with a chief executive that wasn't against the same issues that the legislature was, that we could actually hire somebody to look at this, especially, and I mean, the main thing we were talking about was that the BLM RMP over in Rock Springs when we were looking at this, but the situation's kind of changed on that, but I think that was the purpose, just giving the legislature the ability to hire legal help to defend the state against actions like this.
Okay. Representative Banks.
Mr. Chairman, thank you. I think another important part of this was, it was on page 2 where the legislature declares equal footing and that we're a co-equal branch of government. And if you see there, it says, because that these federal land use plans are matters of great public interest, that we provide standing for the legislature to be able to prosecute such of these interests. And I think that was a really important piece, is that we declare that we are, we have sufficient interest in the proper interpretation of these federal use plans.
Okay, committee, any other discussion? Representative Conrad.
Chairman Eklund, if I recall correctly, which is sometimes challenging, was this in reaction, obviously, as pointed out earlier, the Rock Springs BLM, that would give us equal footing, as you pointed out, that if there's an instance where the governor does not believe in prosecuting or litigating a specific case, we as a legislature can? Is my memory fairly lucid?
Okay.
That's how I recall it. Yeah. Thank you.
All right. Representative Craigo.
Thank you, Mr. Chairman. I actually don't remember the discussion about that. It was not whether, an either or, you know, what the discussion was not, do we wait on the chief executive to file action? It was just, I mean, that's not in this language. It does not, there is not that limiting language in here. It specifically says we can do whatever we want. And so it was not, we're gonna wait and see what, the chief executive does. It's just, hey, here's the ability and, you know, here's the money to do it.
But the primary of initiator would be the governor's office, the executive branch, and then the ability by legislature, because I don't see that in here either. There is no. No. Okay. Well, we don't both want to be spending money on the same thing. And there's a problem if we're fighting with an executive branch that disagrees with us. So I don't know if we can clear that up in the bill or not. Representative Davis.
Yeah, Mr. Chairman, the governor has the FERNERPA fund in order to.
Correct.
And I think the intent of this was to help backfill or give additional funding out there if needed. But apparently I was wrong.
We got a couple. Go ahead, Representative Craigo, and then I'll get to you, John.
Yeah, just, thank you, Mr. Chairman. Just clarification, that was not, the discussion around this was not to backfill the FERNERPA account. It was to just have our own pot of money to do it
Okay.
of whatever we wanted to do with as far as, prosecuting actions regarding these federal issues.
Representative Conrad.
Yeah, Chairman Eklund, thank you, and appreciate Representative Craigo's explanation. That is correct. And as pointed out by Representative Slagle on page 2, line 11, it says co-equal. So that does not mean that he takes first shot, we take second. We're on equal footing in this regards, that we have the opportunity to, at our disclosure, or more importantly, at our decision, we can litigate.
Okay. I think I could have a way of fixing this while we're here.
I guess,
We probably need to get more public testimony, complete that part, so keep on hold, because I think we can fix it, and I think we'll have time to do that too. My concern is you don't want each branch of government fighting on opposite sides of things. You better have a better reason than what this bill was designed for to be doing that, so. Yes, Representative Conrad.
Mr. Chairman, I apologize. I'm not clearly understanding what needs fixed.
I think that one branch of the government or the other probably needs to take the lead on the problem that we had in the Rock Springs plan. And it can be, both branches of government can be on the same page, but I would say the executive office is the first one to respond, because we're not in session and not able to do much about it. So go ahead, Representative Conrad.
Chairman Eklund, respectfully, this was, the genesis of this bill was to ensure, I guess your question or comment, it enabled us, whether or not if there was a disagreement, it gave us that ability. So there was no precedence as it related to whether the executive branch or ourselves did. If we felt as a legislator we needed to litigate, where in the example, as an example, the executive branch didn't think so, this gave us that ability.
Okay. Is that the way everybody understood it? All right. Thank you for that. And let's go down here. Representative Allemond.
Thank you, Mr. Chairman. Yes, sir, you're right, Representative Conrad. We did this to show that we have co-equal power and that we have the right, just as much as anybody else, to sue and bring in outside counsel. Thank you.
Okay. I think we'll go to public testimony first. Is there anyone here in the room who wanted to testify on this bill? We do have someone online. No, we don't have someone online. Must be a different one. Okay. All right. So we don't have anyone online. We'll close testimony. Committee, what's your pleasure? Been moved by Allemond, seconded by Banks. Discussion on the bill. Representative Craigo.
Thank you, Mr. Chairman. I just want to address, one of the issues I see with the bill is I'm not sure it's going to be upheld as constitutional as drafted. And this goes back to this whole language being a co-equal branch of government. Yes, the legislature is a co-equal branch of government. We're one of the three legs on the stool. But we all have different rights and responsibilities within our branch. Our job is to make laws. That's what we do. The executive branch, their job is to enforce those laws. And the judicial branch is to interpret those laws. I always have problems with this language because it oversimplifies what we do. We are a co-equal branch of government, but we have a different job. And our job isn't always to get involved in some of these non-policy decisions. This, in my opinion, I don't mind us getting involved in interests that are exclusive to the legislature. If we need to protect our interests as the legislature, that's what the current statute allows us to do, is to bring suits to do that. I support the idea of fighting back against federal actions that are harmful to Wyoming, and so that's why I struggle with this particular bill, because I feel like we might be overstepping our bounds. We had this discussion on the floor 2 weeks ago about whose job is it to bring actions on behalf of the state, right? I happen to believe it's the executive branch's job to do that. There's a statute. This is going to conflict with that statute. There's a specific statute that provides that the Attorney General is the person whose job it is to bring actions on behalf of the state or to defend the state. And that would include even these particular items. Now, we may disagree with the chief executive, we all do at various times, but that doesn't make what we're doing here constitutional or correct. I'm not saying it isn't either. I'm just throwing that out there, that I think there's a possibility we run into that issue the way it's drafted. And by saying, hey, we're the legislature, we can make a law and we can have it say whatever we want. That doesn't mean it's constitutional, and that we might be overstepping our bounds as far as what we're allowed to do under the terms of the Constitution. So I'm just throwing that out there. The other issue I see, we're specifically saying, and I mentioned this, I think, back in the summer, on line 12, page 3, it says the legislature shall have standing. Well, we don't get to determine if or when we have standing. That's the court's job. Another issue with the way this particular language came out. And so I'm just pointing out what I see are some of the holes with the particular language and the troubling parts of it from a legal perspective, not from a policy perspective, or whether I agree with the idea that we should be fighting back against the Fed's actions and all this stuff, because I think we should. That's not my point. I just want us to pass good policy that's gonna stand up when it gets stuck in the green book. And so those are sort of my comments, Mr. Chairman. I'll most likely vote no because I'm worried that we're going down a road that doesn't help us. I wish there was a way we could figure out to do it, and maybe we can. We might be able to fix this up, but I'm kind of worried about it.
Representative Conrad?
Mr. Chairman, may I propose an amendment at the appropriate time?
Yes.
I'd like to propose an amendment specifically on page 3. Obviously, in reaction to the previous speaker, on line 12, the legislature may, as opposed to shall, have standing and may borrow funds. So the only change in this case, as I commented, is page 3, line 12, removing shall and replacing it with may.
Does that satisfy the legal perspective that you had, Representative Craigo? No.
Mr. Chairman, I actually don't think we need language regarding standing. Either we have it or we don't. I mean, the courts have a way to figure that out. They have precedent, they have rules to determine standing. Us saying it, aye or no, within a particular bill, I don't think is gonna solve that. But that's just my take on that. I don't actually think you need it. I think you could just strike shall have standing from that line. It could say the legislate and shall have standing and it could just say the legislature may borrow funds in accordance with subsection F.
Representative Allemond?
Our Constitution says that we have co-equal governance in the state. So I want to leave in the shall. And then also on the House floor over the last couple weeks, I've heard many, many times that what we do as a body is constitutional until we're told it's not. So I say what we're doing today is 100% constitutional until we're told it's not. Thank you.
I guess what I would say about that, we are co-equal branches of government, but we have different functions. And if somehow the legislature gets involved in a dispute like the Rock Springs plan, the legislature jumps into it before the governor gets there, we could land it in court as a constitutional issue and wouldn't be able to deal with it. I do believe that the governor would have a better chance of expediting a plan that really needs to be worked on right now. And that would be my argument on that part and why we don't want to test the constitutionality of things. Go ahead, Representative Allemond.
Thank you, Mr. Chairman. Yeah, and I agree with that. However, what if the governor doesn't do it? It's left up to the legislature to do it, and we have the money to hire the very best. With this bill, we can hire the very best. Our Attorney General, he's good, but he's not experienced in every facet of the law. And this would allow us to go out and get the very best representation the state could have. Thank you.
Understood. Representative Craigo.
Thank you, Mr. Chairman. I guess just for discussion purposes, because this would help alleviate some of my concerns with the language, I don't really think we need the findings on page 2. I mean, I think we could strike all that. It's either, we don't need to be making a statement. We're just giving, because the heart of the bill is us giving the ability to hire a lawyer to go fight these actions that we don't like, that are coming from back east. So I guess my thought, maybe we could just get rid of the findings. I don't think we need to make a statement to have the right, because we're giving ourselves the right later on in the bill. I don't know if, I'm gonna make that a proposal just for the purposes of discussion, which would just be striking all of,
This is
it'd be striking paragraph B on page 2.
Okay. All right, so that isn't a motion yet, but it
is
is a motion.
Yes.
Okay, Representative Conrad, I'm gonna second that, but,
I thought we were still back on my original amendment where it was on page 3. I know we're pretty excited here.
I know,
I had a motion for an amendment on page 3, and I was going to accept the good lawyer's recommendation and strike shall have standing and to the earlier conversation we began with. That's where we started.
okay. So you made a motion?
I did.
Did somebody second that? Okay, so okay, now we have two motions on the floor. I don't know how to do this because I'm not real good with Robert's rules sometimes. So I'm gonna say that we'll start with the first one that was proposed by Representative Conrad.
And to clarify that,
Let's
Mr.
discuss that part first.
Okay, I just want to clarify, Mr. Chairman, so that Mark is understanding that on page 3, line 12, delete shall have standing and. Clear? Thank you.
Do we have a may or a shall borrow funds? May, okay. No? Oh, you've left it there. I'm sorry, I crossed that out. Okay. Mr. Secretary, do you have what our motion is? Okay. Are we ready to vote on that amendment? All those in favor of that amendment, say aye.
Aye.
Opposed?
No.
Well, we're divided here. All, surprise. All in favor of that motion, raise your hand. 1, 2, 3, 4. Opposed? 1, 2, 3, 4, and I'm going to be an aye because we don't. It's always argued about whether that phrase needs to be in there, has standing. It's obvious we will butt our way in if one way or another. So I'm going to say it aye. So that motion passes. Next amendment that's on the table has been moved and seconded, would pretty much eliminate which page? Page 2. Do you have anything more to discussion on it, Representative Schlegel?
Thank you, Mr. Chair. I guess my comments are, because of legislation that's been challenged in court here the last couple of years, and what the courts have said in their rulings, I feel putting findings in our laws gives the courts some background of where we've ruled from as we were legislating. And so I would vote against this amendment because I think it's important to have the findings in our legislation so the courts have an idea when they're ruling where the legislature was coming from when we passed this law.
Any other discussion? Yeah, Representative Almond.
I also would vote against removing this because it kind of gives the reason we're doing this bill. And I think it's a good statement for us to put out there. Thank you.
Right. So I guess a question I've got is, in most legislation, we don't put in findings. If we do put in findings, and if this becomes a constitutional question, which you've suggested it could become, then does that add an extra layer that the courts have to determine before they can get to the meat of the issue, which is whether or not legislature can become involved in a land use planning deal? Go ahead, Representative Craigo.
I don't think so, Mr. Chairman. I mean, this would be subject to a challenge by some third party. The court's not gonna consider whether we, for example, if we decide to hire outside counsel to prosecute an action against, for example, the Bureau of Land Management or something, that's not gonna be a question before the court at that time. This would have to be subject to some, a declaratory judgment action brought by some third party who says, hey, legislature, you don't have the power to do what you just passed the law saying you do have the power to do. And it'd come down to a constitutional question and whether this particular section in Title 28 can override a different section in Title 9, which is what the Attorney General's job is, and then going back and comparing those to the Constitution. This just causes me concern from a legal perspective, not from a policy perspective. So I just want to make that clear. I'm just worried about, if we're going to pass a law, I'd like it to be as likely to succeed as possible. That's my concern. And I actually think this hurts us rather than helps us. That's why I brought the amendment. Whether it stays in, doesn't stay in, it's not going to matter one way or the other, but at least getting the standing part out helps me a lot more, because then we're not stepping on some other branch's toes explicitly.
Representative Allemond.
Thank you, Mr. Chairman. So Representative Craigo, in court, you don't think this hurts us or helps us, either one? It's the crust of the bill that would be looked at in the court, not the findings. Am I correct in that?
Mr. Chairman?
Yes, sir.
Representative Alaman, so what I would say is it depends which action we're talking about. If we're bringing in action against the federal government, for example, this does us no good. This does not matter. The court is not going to look at that, which is my point. If we get sued, if the state gets sued after this is passed, someone challenges this particular law as unconstitutional, I then think this actually hurts us. It doesn't, well, no, at that point, I think it hurts us because if someone says, hey, legislature, you're overstepping your bounds, you're not allowed to do what you're trying to do on multiple levels. One, we're saying, hey, this would be my argument if I'm opposing counsel, right? Hey, legislature, you're trying to take over the job of the executive branch. You can't do that. You're overstepping your bounds. And that would be all of what I would say is page 2. And then page 3, we're also telling the court what their job is, which we fixed that by taking that language out. So that helps me a lot, actually. So, we were stepping on both other branches' toes previously. Now I think it's just probably one. Hopefully that helps. So it sort of depends which action we're talking about. If back to my original statement, if it's an action of us suing the BLM or someone else, none of this is going to come into play other than gives us the right and the money to do so.
Okay. I don't believe there was anything in here that referred to what we think is the meat of the bill, which is to provide funding if we need it. And I guess I'm wondering if we put this in, if it doesn't narrow down what kind of land use plans and what kind of actions we might be able to do concerning those, because although I think most of it is already in statute co-equal, we're. Okay, question on the amendment. The amendment would be to strike section B on page 2. No further discussion? I think we're ready to vote. All those in favor of amendment number 2, please say aye.
Aye.
Opposed?
No.
Well, let's have a show of hands. All those in favor, raise your hand. 1, 2, 3, 4. Okay, opposed? 2, 3, 4. I'm gonna go with the ayes again, and I You can challenge it with a committee of the whole amendment, but I just, we don't see this in statute much, so, if at all. So that's concerning to very much from what we regularly do. All right, any further discussion on the bill? Yes, Representative Davis. Let's not forget the meat of the bill, right?
Right, the meat of the bill. And my question, Mr. Chairman, is, it seems like we're extending authority to management council here in a couple of positions, you know. And I guess my question is, with the adoption of this bill, does that direct the management council to prosecute the action on behalf of the legislation? Or is this enacted, you know, the management council by the affirmative vote of 2/3 of the members of the council during the interim? I guess I'm a little confused in there. Who's calling or who's turning on the green light? Who's turning on the red light?
Representative Craigo.
Thank you, Mr. Chairman. So Representative Davis, that's the existing statute, and that's how it works right now. So if we're not in session and management council decides that this is something important needs to happen by 2/3 vote, they can make it happen. If we're in session, then it would go through us, through the body. And so I think that's we're not changing that. And so the only part we're adding there on the middle of page 3 is the language regarding federal acts. Yep.
Thank you.
And the last 2 pages.
Thank you for clarification.
Okay. Any further discussion? Question on the bill. I guess we're ready to vote.
Representative Alleman. Aye. Representative Allred.
Aye.
Representative Banks.
Aye.
Representative Conrad.
Aye.
Representative Craigo.
Aye.
Representative Davis.
Aye.
Representative Slagle.
Aye.
Representative Winter.
Aye.
Chairman Eklund.
Aye.
9-0, to pass with amendments.
Okay, the next bill for our consideration, I can't find the bill number.
103.
The Senate File 103. And here to, we've got the prime sponsor and any helpers you want to bring forward. Go ahead, Senator.
Prime sponsor, no pun intended.
Thank you, Mr. Chairman. I present to you the Wyoming Prime Act. Let me very briefly, I know some of you've all read it, but let me very quickly go over it. First of all, the Wyoming Prime Act is a trigger bill. It will only take effect if the feds pass the federal Prime Act, and that's before Congress right now. So this bill that's before you can only take effect if Congress passes the Prime Act. And I will tell you that one of our Congressman Hageman is a co-sponsor of this. So, so the Prime Act, in a nutshell, committee, allows local farmers and ranchers to sell their beef without USDA inspection. Now, they do still have to go through a slaughterhouse, which is obviously inspected by the state, but there are obvious advantages to going this route. Primarily, this was brought forward because, you know, our citizens want fresh local beef. And we'd like to keep those dollars within the community, whether it be farmers markets. And it also gives our farmers and ranchers the freedom to do this. Now, I will tell you straight up, there are a lot of sideboards to this. And if you look at page 3 on the bill, a producer may sell meat products from cattle, sheep, swine, or goats raised by the producer that were slaughtered on the premises of the producer or at a custom slaughter facility if the following conditions are met. Number 1, the meat products are produced from animals
that are raised, slaughtered, processed, and sold in Wyoming. Number 2, the meat products are sold directly to an informed end consumer in Wyoming, whether for consumption on or off the premises. Number 3, a prominent written warning statement shall be delivered to the informed end consumer at the time of sale, or the warning may be displayed on a label affixed to the meat product, and the warning required by this paragraph shall state the meat product has not been inspected and is not regulated. And number B on that, the informed end consumer who obtains meat products pursuant to this act may agrees not to sell, donate, or commercially redistribute the meat. So there are plenty of sideboards to this. But again, I think that for most of you who are in the agricultural business, you can see the advantage to this. I know that during COVID, particularly, the USD inspection houses were backed up with regard to farmers and ranchers trying to get their beef in it. I actually believe, and it's my opinion, that this could very easily lower the cost of food. And then you all know what the cost of food is. It's skyrocketing, particularly meat. And I think our citizens would like to see an alternative where they could spend less on their meat, have it fresh, make it local, and keep that money in our community. And at the same time, give our ranchers and farmers the freedom to do this. So with that, I stand for any questions that you may have.
Committee questions, Representative Allemond.
Thank you, Mr. Chairman. Mr. Senator, I love this idea. I have a question, and it's on page 4, line 7. Would it hurt this bill to strike that line? That would allow the meat to be sold to a wholesaler who could then sell it to a retailer. And this line would prevent that as of right now. I don't know. I think it would, but would that hurt the bill if we struck that?
Let me get the opinion of the father of the Food Freedom Act, which is
Yeah.
former Representative Lindholm.
Thank you, Mr. Chairman.
Yes, welcome to the committee.
Yeah, thank you, Mr. Chairman. Tyler Lindholm, State Director of Americans for Prosperity here in the state of Wyoming. Had a long evening last night, pardon me, Mr. Chairman. To Representative Allemond's question, the reason for that language and why it's important is it actually is kind of utilizing existing language that is in the Food Freedom Act, but it also points back to the Federal Meat Inspection Act, which governs essentially meat processing here in the United States. And by saying that you can't redistribute after that original retail sale, that falls in line with the intent of what the Prime Act, HR 2814, would read. So it's just ensuring that we're staying within that lane.
Okay, a follow-up.
Follow-up.
Would I be able to sell it to the... I shut it off instead of turned it on. Would I be able to sell it to the packer, and would he be allowed to sell it through a sale case?
You're talking about on the hoof, probably. So,
Yes, I'd sell it to the packer on the hoof, and then would he be able to slaughter it and then sell it through his packing plant?
Mr. Chairman?
yes.
Mr. Chairman, to the representative's question, yes, if it was a custom slaughter facility, that would specifically what this bill would go after. Right now, with state inspected or federally inspected facilities, they can do that already. This would allow those custom slaughter facilities to be able to do that. And as you know, Representative, those custom slaughter facilities are far more prevalent in all of our communities than state or federally inspected.
Sure. Representative Schlegel.
Kind of question, thank you, Mr. Chairman. Question following up on that, kind of along the same lines. I know right now, if producers are selling eggs, they cannot sell eggs to restaurants because they haven't been inspected. And I was wondering, is it the same here with our meat product? Could an individual rancher or farmer sell meat to a restaurant and then be distributed without problems.
Mr. Chairman, to Representative Slagle's question, so that's where the USDA comes along with their inspected policy that they have. When it comes to non-inspected items, as soon as they enter an inspected environment, that's when the red flag goes up. So if it was inspected beforehand, then it can go there. And also sometimes they get a little ornery about inspected to non-inspected produced items. Basically, they're the worst, Representative Slagle. But that being said, I suspect if the Prime Act at the federal level were to pass, and this piece of legislation that Senator Salazar has before you, in that situation, the feds would look at it much the same way, where because it is an uninspected item, it did not go through a state or federally inspected plant. At that point, they would not allow that at a local restaurant.
And, excuse me.
I just want to say thank you.
And I would add, Mr. Chairman, that if this were to pass, that we will be the first in the country. We'll be the first in the country, which is going to put pressure on Congress. I think other states are going to follow if Wyoming goes forward. It makes sense. It provides greater freedom. It lowers the cost of food, gives better freedom to our ranchers and farmers, keeps those local dollars in all our communities, and it's going to regenerize the farm markets that we have in our local community. So I just think it's a win-win, and yes. So.
Okay, any further questions? So just clarity, we're mainly dealing with custom processing facility. And it kind of indicates that when you get to page 4, line 4, meat product has not been inspected and is not regulated, because the other two have some inspection. All right, so this is probably a bill that needs to stay like it is because other states are looking at it the same way. Okay. Go ahead.
Yeah, thank you, Mr. Chairman. And just for clarification for yourself and the committee, the main Prime Act, HR 2814, of which there is a Senate companion also, and Senator Cynthia Lummis is also a co-sponsor. What that legislation does at the federal level is it says that states may so choose to allow their custom slaughter facilities to retail. That's all the legislation does. As it currently stands under the Federal Meat Inspection Act, that is against the law. The USDA gets really ornery about that. We've run multiple pieces of legislation that has provided the Wyoming Department of Agriculture no shortage of headache, because it's a really good idea. But in this situation, this is following what the federal law would change. And that would be to allow these custom slaughter facilities to be able to do these types of activities. But the federal law does specifically say that states have to choose to do this. So Senator Salazar's trigger bill would put Wyoming at the very front to immediately pull that trigger.
Okay, any other questions? All right. Thank you. Any further testimony?
Oh,
I didn't see your hand.
oh, okay. I would just say that during the last few years, this bill would have really helped people with the markets and also with the provision of food for the people of Wyoming. It was very difficult to obtain things, to run their businesses, and also to feed the people locally, which would have really been of help, especially in our county where, oh, and I didn't say Pepper Ottman, House
Yes, I
District
was
34. Yes, yes.
Going to,
Well, I was trying to figure out, but I would say that when it was difficult for transportation and markets and trucks to get out and through, these local facilities would have really been advantageous to the people. And we may see those types of things again. So I'm very in support of this and hope that it goes further. Yeah, thank you.
Thank you. Any questions for Representative Ottman? You did? She's running off. Pepper, come on back. Representative Winter has a question.
Yes.
Yes, thank you, Mr. Chairman. I should have asked this question when Mr. Lindholm and Senator Salazar were here, but
Friend.
I guess, does the state still inspect this meat at some point?
I think, well, it's on the hoof, but I will phone a friend. Thank you.
Mr. Chairman, if I could?
You may.
It wouldn't be considered inspected. The type of inspection that happens at a custom slaughter facility is the same type of individual that goes by and looks at our commercial restaurants. So that kind of look, but not inspected as we would otherwise recognize at state or federally inspected sites. There's nobody cracking a rib, so to speak.
Okay. So basically, a brand inspection would be the inspection that would be there.
Mr. Chairman, that would be correct. And then also the once a month or however often these individuals that make sure the bins are clean kind of deal.
Okay. All right. Thank you for bringing the bill as well. We have further testimony. Come on up.
Mr. Chairman, committee, thank you. My name is Kelly Carpenter with the Wyoming Farm Bureau Federation. I will keep my comments very brief. Our members support this legislation. We appreciate the trigger aspect of the bill. And anytime we can keep all of our agencies happy and make it easier for our ranchers to get the product to the consumers, we're all for it. So thank you, and I'll stand for any questions.
Committee questions? Thank you, Mrs. Carpenter. Good morning. Welcome to the committee.
Good morning, Mr. Chairman, members of the committee. My name is Claire Duder, and I'm with Powder River Basin Resource Council. We urge your support on this bill. This is a good bill for Wyoming. And we support reducing barriers for locally produced foods. And we support facilitating consumer choice when it comes to high quality, locally produced foods. So we urge your support, and thank you.
Questions? Thank you, Mrs. Duer. Any further testimony? No one online? Oh, we do have someone online. Okay. Bring them on when you can, Tanner.
Hello, Mr. Chairman and members of the committee. Can you hear me?
Yes.
My name is Laura Tolliver Pearson. I am a sheep rancher in Southwest Wyoming. I would urge an aye vote on this bill, as the current policies have affected us. Currently, and I don't know if you know this, but we have to, if someone wants a lamb from us, they have to get a brand inspection of the lamb on the hoof. So basically a transfer of ownership before that animal is slaughtered. In our instance, we usually keep about 15 to 20 lambs for slaughter in the spring. And under the current rule, legally, we are not able to sell that boxed lamb, even though it goes through a state inspected facility, but it's not USDA. We're not legally able to sell that lamb because we didn't sell it beforehand on the hoof, if that makes sense to you. So this would really help Wyoming producers be able to take their lamb or their beef or whatever to a farmer's market, say, and be able to sell that lamb at a cheaper price than you would be able to sell it in the store. I would urge an aye vote on this bill, as it will help Wyoming producers of meat across the state.
Okay, thank you, Ms. Pearson. Any questions?
Thank you.
Thanks. Okay, committee, I think we'll close testimony. Not close. Okay, go ahead. Representative Craigo.
Thank you, Mr. Chairman. I forgot to ask the good prime sponsor how this bill got off the floor in the Senate without including the word yak on the list of animals that are available for slaughter, because I know there's a particular senator from Campbell County that slaughters a lot of those.
Mr. Chairman, if I could?
You may.
Mr. Chairman, members of the committee, I'm the geekiest guy you'll ever meet about food law besides the Wyoming Department of Agriculture. So actually, yak is not governed by the Federal Meat Inspection Act and is governed by a different piece of legislation altogether. Neither are chickens, that's why you're not seeing chickens under this. Neither are fish, neither are rabbits, and the list goes on. Neither are buffalo. Those animals do not grow bacteria, Mr. Chairman, when they spoil. That's why the USDA has deemed them to be far safer than beef cattle. I know it doesn't make sense, neither does the USDA. Please vote aye.
So does that settles your concerns about the purity of buffalo and what have you?
It does. Thank you,
Okay.
Mr. Chairman.
All
Well,
right.
somebody's gonna
Thank you.
ask us that when we get to the floor, so
Oh, yeah.
I wanted to know the answer.
Okay, any further discussion? I believe we are ready to vote. No changes to the bill because we better not do it. It's something that could be triggered by other states, so we'll just leave it consistent with what the other states might do. All those in well, nope. Roll call vote is what we need.
Motion.
Huh?
Don't you need to move?
Oh, we haven't moved it. Been moved? Seconded by Slagle. I'm certainly out of order this morning. Thank you, Mr. Secretary. And committee, the reason this is important, you have kind of an old fuddy-duddy chairman who's really, really rusty on Robert's rules, haven't been in FFA for a long time. The reason it's important is it's all on record. And one time we did something that wasn't correct parliamentary procedure and had to reconvene briefly to redo my mess up. So thank you, Mr. Secretary, for catching that. It's been moved and seconded. We'll have a roll call on the bill.
Representative Alderman. Aye. Representative Allred.
Aye.
Representative Banks.
Aye.
Representative Conrad.
Aye.
Representative Craigo.
Aye.
Representative Davis.
Aye.
Representative Slagle.
Aye.
Representative Winter.
Aye.
Chairman Eklund.
Aye.
9 aye, 0 no, do pass.
Okay, thank you, everybody. This was a good meeting, and we will adjourn right now and make it to the floor before they gavel in.